Hi, I'm Luigi Lucarelli, and I'm going to talk to you today about a piece of interpreting history, which is the United States Federal Trade Commission's investigation of translator-interpreter associations way back in the early 1990s. The Federal Trade Commission, or FTC, is a United States regulatory body charged with enforcing what's called antitrust or competition law. In the year 1990, basically, they started looking into translator-interpreter associations. What we've learned over time is that actually it's not that they all of a sudden discovered our field, but that actually three agencies had anonymously filed a complaint, not about AIIC, but about the American Translators Association and the fact that they used to recommend rates for translation in their bulletin. So I think that is a good starting point because it relates to something that we are all very much aware of today, and that is an increasing dominance of intermediaries, agencies in our market. And it's interesting that this investigation was begun, at least indirectly, by some agencies. So if we go back to 1990, what happened is they took up an initial investigation of the American Translators Association, then went on to look into some national associations in the United States, including the National Court Interpreters Association, another association of translators and interpreters called the American Association of Language Specialists, and also a small association called the American Society of Interpreters, which doesn't exist at this time. Then they came to AIIC. Now it's important to know a bit about the process. When an investigation of this kind occurs, they will approach an association. In this case, it might have been a business in other areas of life, and say what they think has been done wrong and offer the group, the association, to sign a consent order rather than go to court. Now, a consent order basically looks like a court order that lays out all their conclusions, but then allows you to sign it and promise never to do any of this again, although you're not admitting guilt. So it's an easy way out. Some of the other associations that were asked to sign one, namely the American Association of Language Specialists and the American Society of Interpreters, did exactly that. AIIC, which granted was a larger and therefore wealthier association than these two, and also was different because it was international and had other concerns, decided to battle against them. What was AIIC's reasoning at the time? Well, it was quite simple, really. One, it said, we stopped any recommendations of rates quite a while ago. We've made that quite clear. So we don't mind saying that we won't do that again because we're not doing it now. But our working conditions and some of our code of ethics which relate to working conditions can't be touched. We feel that they strongly affect the quality of interpreting on the one hand and the long-term health of interpreters on the other. And it even went beyond that, because on what many of us call our union side, AIIC does negotiate collective agreements with a number of international organizations, such as the United Nations, the European Union, and a few others. And we felt that not defending our working conditions, the very ones that we agreed to with them, would not be positive for the long-term success of our profession. So we said that we were willing to fight for those. Now, this began a rather long process, actually. It's an administrative law, not a criminal law process in the United States, so that we had to prepare a case, as did the law staff, the lawyers of the Federal Trade Commission. And the first stop, after a couple years of preparation, was before an administrative law judge who also happens to be within the Federal Trade Commission. That law judge basically sided with their lawyers, which we fully expected to happen. From there, we appealed to the commission. And that turned out to be a very interesting process too. It meant refining our arguments. It meant also getting an expert witness to help define and corroborate the arguments we were putting forward about quality and interpreter health. And then it was also a question of having the court proceeding itself. So we went forward with that. In the meantime, also, I should mention that another group that had been formed in the United States called the Translator Interpreters Guild, that at the time was actually affiliated to the Communication Workers of America, a union, filed an amicus brief. In other words, a friend of the court brief, backing us up wholesale on all those arguments, which certainly was appreciated and needs to be recognized. These papers were all handed into the commissioners who acted as the judges on this final appeal. A very interesting process. I myself did have to appear and help explain our own reasoning, but also stand in for questioning. An interesting thing happened when I was actually on the stand, because the FTC lawyers approached and basically tried to make the argument that the fact that their research into AIIC interpreters and their contracts, etc., had shown that nobody was charging more than the United Nations, and that obviously this meant that we were somehow controlling them more or less in a very small range of prices close to the UN price, which somehow to them was an argument for saying we were controlling the market. And they asked my opinion on that, if I had anything to say about that. And I simply said, well, you do know, I believe, that the UN rates, the amounts that the UN pay interpreters, is tax-free. So it's actually much more than the rates you're seeing. It's nowhere, which are not even close to what the value of before tax money would be on the UN rates. And that threw them into a tizzy. They asked for a recess in the hearings to discuss it. It affected, almost I should say, affected me personally, because the next day they asked their commissioners to subpoena 5 years of my tax records to try to see if they could find out more about this. And they asked AIIC to produce a copy of our agreement actually stating that this was tax-free money. We responded to that. Unfortunately, the commissioners said that they couldn't subpoena my tax records, and they backed up our argument about the UN, saying if they wanted proof of that, all they had to do was ask the United States government for the headquarters agreement, because it's all established in the headquarters agreement between the United States government and the UN. The final decision of the commissioners, we felt, was an absolute success for us. Of course, there is still that part on rates, which, according to the way the FTC works, that anything, whether it's recommended or ranges or suggestions, simply is a no-no. So that still was issued as an order that AIIC could not do that. which, as I said before, would have willingly signed at the beginning if they hadn't included the rest. But the FTC commissioners now took out the rest. So our victory, in a sense, was a silent one, in that what we won was that nothing about our working conditions was stipulated in that final order. In other words, we could continue to hold on to those conditions that anyone joining AIIC swore to uphold them. And we felt that that was a very important victory. So, moreover, when you do read the opinions of the commissioners themselves, you do find that comments to the effect that although we do not have to rule on the arguments in favor of the working conditions proffered by AIIC, because the FTC lawyers didn't prove that we had enough market power to really exert any effect on the market, that nevertheless they were certainly worthy of consideration, namely, as I said before, quality and long-term health, and the fact that long-term health actually means more quality interpreters staying in the market through more of their life. So that was an interesting point of it. One other thing that we thought was extremely important, since they had brought up the subject of the UN in the courtroom, we then turned around and wrote a clause on agreements that we suggested that the commissioners put into any decision they made, which was formal recognition of the agreements we then had, and that any such further agreements with other organizations or businesses in the future, when the two sides agreed to negotiate one, were certainly not only legal and valid, but perfectly acceptable, no problem. It wasn't going to get us into any kind of trouble. So that was the victory that we saw. To us, that also meant that we had given a good example of what a professional association really can be. That a professional association can work for the collective and individual good of its members and offer what I think was a very positive example. And it might be interesting to just read you a little quote here. This is actually a note that was sent to us by our lawyer, and as you probably gathered from the little talk I just gave, during this whole period, I was the AIIC Council member for the United States. So I was the connection between AIIC International and our law team in Washington. I spent so much time with them that they wanted to give me an honorary degree in competition law. But that's the kind of thing you do over dinner and a drink, not in reality. But here's the note that our lawyer sent to the AIIC office. He said that a couple days after the decision came out, he received a note from the FTC staff lawyer who had made the oral arguments before the commission, and who was certainly quite aggressive, as you would expect, throughout those oral proceedings. And this staff lawyer said to him, or I should say wrote to him, "Congratulations on your stunning, and I mean that quite literally, victory for AIIC. If I see you at the American Bar Association spring meetings, I promise to cry in my beer."